Good afternoon. Our second case scheduled for oral argument this afternoon is R.J. Reynolds Tobacco Company versus Margaret Harris et al. Is counsel ready to proceed?
Yes, Your Honor.
Again, counsel, we are allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I would like to reserve 3 minutes of my time for rebuttal.
So noted. You may continue, counsel.
Thank you. May it please the court, and good afternoon. Jason Burnett on behalf of the appellant, R.J. Reynolds. The issue that we've raised here is not unique to Engle cases. On page 25 of our initial brief, we cited 2 cases where courts have considered how juries should be instructed when a default judgment has been entered on the compensatory liability claims and compensatory damages, and all that remains is a trial on punitive damages. One of those cases is this court's decision in Nordine. In the Nordine case, the court affirmed the default judgment, and the case was going back down for a trial on punitive damages only. And the court prophylactically addressed how the jury should be instructed in such a case and how the proceedings should go forward. And 2 points of note. First, the key point is the jury was to be given no instruction on the underlying tort claims in that case for fraud or interference with business relationships. Instead, this court directed the trial court to instruct the jury that it had already determined that the defendant had committed acts for which punitive damages were an available remedy, and that the jury should not concern itself with those issues. So an affirmative instruction to the jury not to concern itself with the underlying tort claims about which the jury would be told nothing. The second point is that the parties would have no limitation on the evidence that they could introduce to support their contentions as to those 2 claims. All of the conduct evidence related to fraud and interference with business relationships would be introduced so that the jury could fulfill its function of deciding whether that conduct was so egregious that punitive damages should be imposed. The second case is the Bell-Glade case from the 4th DCA. That followed this court's decision in Nordine, and it followed an actual trial, jury trial, on the question of punitive damages. And the issue was the propriety of the jury instructions on appeal for punitive damages. The court found, 4th DCA, determined that the instructions were erroneous and had to send the case back down. Here were the instructions. The trial court instructed the jury that it had determined as a matter of law that the defendant had deprived or acted with criminal intent to deprive the plaintiff of his property, that the defendant had engaged in unconscionable conduct, and that the defendant had made knowing misrepresentations. These were just the elements of the underlying tort claims. But by instructing the jury that the court had determined them as a matter of law, and that the jury must accept them, and because these elements related to the questions for punitive damages, whether the conduct was so egregious that punitive damages should be awarded, the 4th DCA determined that the instructions were erroneous because they interfered with the jury's ability to make an independent assessment of the conduct for punitive damages. So that's exactly what we have here, Your Honors. We have an instruction on the Engle findings. The instruction on the findings do relate to conduct that is the basis, can be the basis for punitive damages as well. And the jury was instructed by Judge Gievers that it had to accept the findings. The findings were binding. They could not be denied or questioned. Now, we don't have an objection to those instructions as they relate to the compensatory liability claims. But once you tell the jury that the jury may consider the Engle findings for purposes of punitive damages, then you run squarely into the problem that you had in Nordine and Bell-Glade. You're telling the jury, affirmatively encouraging the jury, to consider findings that are not admissible because they're made under a lower standard of proof. You're telling the jury those findings cannot be denied or questioned, and those findings relate directly to questions the jury is tasked with evaluating for purposes of punitive damages. Now, look at the finding on defect. That finding told the jury that Reynolds marketed defective cigarettes that were unreasonably dangerous. That finding relates to the questions for punitive entitlement. And just to be clear, this is a pre-1999 case. The jury was properly instructed with the pre-1999 standards for punitive damages, which is a 4-factor test. Those factors are basically, and I'm paraphrasing just a bit, whether the conduct was gross and flagrant, showing reckless disregard for life and safety, whether there was entire lack of care equivalent to conscious indifference to the consequences, whether there was wanton and reckless disregard for the safety and welfare of the public, and whether there was reckless indifference to the rights of others amounting to an intentional violation. Well, the jury in this case was told that as for finding three, actually, the defect finding of the Engel findings, that Reynolds marketed cigarettes that were defective and unreasonably dangerous. On the concealment claim, the concealment finding, the jury was instructed that Reynolds concealed material information about the risks of smoking, knowing that the information was false and misleading. And on the conspiracy claim, the jury was instructed with the finding that Reynolds conspired with others to conceal the risks with the intention that the public would rely. Those findings speak directly to whether there was wanton and reckless disregard for the safety and welfare of the public. The problem is those findings are not admissible for the purposes of punitive damages, and those findings were given to the jury in a way that told them they could not question them, they could not deny them. There's every reasonable possibility, which is the standard here, reasonable possibility that the jury was confused and misled into thinking that it could accept these findings and find that punitive damages must be awarded. Now plaintiff's primary argument here is that the jury had to be instructed with the findings because the findings are the basis for compensatory liability, and without compensatory liability, you don't have punitive damages. But the cases I've just discussed show that that's not true. There is no need to instruct the jury as to the underlying tort claims, and in fact, you shouldn't tell the jury anything about the underlying tort claims if the only issue is punitive damages. The jury should be instructed not to concern itself with those issues. And that's exactly what the Florida Supreme Court said in the Sofer decision in two different places. Page 1222, 1232, the court held that the questions for punitive entitlement, which must be decided by clear and convincing evidence, quote, do not vary depending on the underlying legal theory. The legal rubric of defect or negligence or concealment or conspiracy doesn't matter. What matters are these four factors for punitive damages that must be decided by clear and convincing evidence. And as long as the parties have been able to introduce all of the evidence of the conduct going to those questions, there's no need to instruct the jury at all with regard to the findings. Now, something else the plaintiffs say in their answer brief is that the findings were the only source of information of defect, negligence, concealment, and conspiracy. That simply is not true. In this case, as in every other Engel progeny case, the plaintiffs introduced evidence independent of the findings to support their claim for punitive damages, evidence of a defect. The plaintiff's trial counsel in closing argument summarized all of this evidence in 12 pages from the 2-week trial, explaining why this evidence showed they were entitled to punitive damages. You can look at those pages. It starts on page 1807, 12 pages summarizing the evidence, independent evidence of defect, negligence, concealment, conspiracy. They argue that cigarettes were defective because they are inhalable. They argue that cigarettes are defective because they have carcinogens. They cause disease. And this was the main contention in this case. They argued that cigarettes that Mr. Harris smoked were defective because he smoked filtered cigarettes. And filtered cigarettes are no safer. In fact, they're more dangerous than regular cigarettes. And that Reynolds committed fraud by concealing this evidence from the public. So all of the evidence that plaintiffs claim needs to come forward to the jury so that it can make a proper determination of punitive damages was admitted in this case. What you have is the plaintiffs doubling up on the defendants. Not only did they have the independent evidence that they introduced, they also had this instruction that the jury may consider the Engel findings, which is a separate jury, deciding a separate issue under a separate burden of proof. Again, the standard here is if there is a reasonable possibility that the jury was misled or confused, and there's every reason to think that by affirmatively encouraging the jury to consider the findings, that the jury, in fact, did consider the findings.
Did the trial court instruct the jury on the plaintiff's burden of proof for punitive damages?
Yes, Judge Lewis. The trial court did instruct the jury that for punitive entitlement, the standard of proof was clear and convincing evidence, that standard differs from the greater weight of the evidence, and that it requires affirm conviction without hesitancy in the belief of the matters asserted. Here's the important part. There was never any instruction to the jury that the Engel findings were made to a lower standard of proof. And I'm not suggesting that such an instruction would have cured things. I mean, you can't just instruct the jury, well, the Engel findings were not made to that standard of proof. In our view, and in the correct view, the Engel findings are not admissible at all. They don't even play a role. They're not even a step in the direction towards clear and convincing evidence. And the two best cases for that are the Cicada case, which we cite from the 3rd District, which notes that results from a prior case are not admissible, and the DuBose case from the Florida Supreme Court. It's a 1943 case, so it's quite old, but it does summarize the evidence in the Wharton Treatise and notes that judgments in a prior case are not admissible. Judgments in a civil case are not admissible in a criminal case because of the different standards of proof, and judgments in a criminal case are not admissible in a civil case because of the different functions of those two tribunals. And so there's no real serious dispute that I've seen in the briefing as to the admissibility of the findings for punitive damages. The argument seems to be that because they are necessary for compensatory liability, the jury must consider them for punitive damages. But the cases that I described at the outset show that that's not the case. Merely instruct the jury with the 4 factors for punitive entitlement and let them consider all of the evidence. I don't want to take up all the air in the virtual room. If there are no questions at the time, I'll reserve the balance of my time and address the arguments on rebuttal.
Counsel. You may proceed, counsel.
Yes, thank you, Your Honor. In Engel cases, a plaintiff begins the case trying to prove class membership. If a plaintiff proves class membership, then those Engel findings become the law of this case. The jury is instructed, consistent with this court's decision in Martin, that the findings are binding on the jury, and they must not be questioned. They must be taken as true. Those findings are incredibly important because those findings present the basis for the causes of action that are brought by a plaintiff. The causes of action are for product defect and fraud and conspiracy. Now, Mr. Burnett has said that we don't need the findings, as plaintiffs don't need the findings. Your Honor, may I ask that Mr. Burnett mute his microphone so that the picture doesn't change around a lot? Yes, thank you. The findings are they show product defect, they show negligence, fraud, and conspiracy. Mr. Burnett has said that the plaintiff in this case presented evidence of all those things, and that simply isn't true. The plaintiff here presented evidence that R.J. Reynolds went the step further, the Albin step, the Piper Aircraft step, where they knew that it was defective, and we presented all the evidence that the product was defective. According to that, we presented the evidence that the R.J. Reynolds scientists recognized that cigarettes were addictive, that they were selling nicotine, and that the cigarettes caused disease. We presented that not as proof of a defect, but as proof of the egregiousness of the conduct. Just like in Piper Aircraft, where Piper Aircraft sold an airplane after the test pilot had told them that the door blew off, and there was a problem with the airplane, and they decided not to do anything about it and sell it anyway. That's the conduct that is the basis for punitive damages. The punitive damages, Judge Lewis, as you noted in your dissent in the Sofer opinion, it's not a cause of action. It's just an element of damages. And that's the same thing the Florida Supreme Court said. But now what R.J. Reynolds does here is they start to truncate parts of the Sofer opinion, and Judge Lewis, they truncate what you wrote in your dissent to the district court decision, where you say that her reliance on the phase 1 findings was not relevant to her claim for damages. R.J. Reynolds says the phase 1 findings were not relevant to her claim for punitive damages. They have taken the words you wrote, chopped off the important part that it is her reliance on the phase 1 findings that are not relevant, and then try to make it sound like you were saying something else, that you were saying that the phase 1 findings are not relevant. But the phase 1 findings are absolutely critical because punitive damages is not a separate cause of action. They are just an element of damage. We have to have a cause of action. We have to have product defect, we have to have fraud, we have to have conspiracy. And without those, we get a situation that was encountered in the 3rd District case of R.J. Reynolds versus Lido, where R.J. Reynolds convinced the trial court to give a jury instruction that said punitive damages are not to be considered, and the jury found entitlement to punitive damages, but then the trial judge took that finding away, entered a directed verdict because the court said that the plaintiff did not prove that there was a defect, and the 3rd DCA reversed it because the plaintiff does not have to prove that there's a defect. The plaintiff only has to prove the egregious nature of the conduct. The other part that that R.J. Reynolds has altered is the Supreme Court opinion where they wrote, we agree with Hallgren and accordingly, this is Sofer again, we agree with Hallgren and accordingly conclude that the res judicata effect of the phase 1 findings addressed in Engel has no application. Again, they cut it off and said, and then they write that, and they argued to the trial court that Sofer, the Supreme Court opinion in Sofer, said that the phase 1 findings have in Engel have no application. And that is just not true. The phase 1 findings are critical. And R.J. Reynolds can't change the law. They can't change the meaning of these opinions simply by taking words that are critical to the sentences and throwing them away. They need to live by what the Supreme Court found. The Supreme Court in Sofer said Douglas says that the findings are carried through, but the res judicata effect of those findings does not mean that the elements of damage, punitive damages, that were not decided in Engel are also res judicata. It is the res judicata effect of the findings have no effect, have no application to whether there's res judicata as to the punitive damages. So we get to this case, and here the jury is told that just like in Martin, that the Engel findings are binding on them; they cannot be questioned. Now, if that was left alone, if that just went off to the end of the case, then we have two possibilities. We have that the jury is going to say, wow, the Engel findings are binding on us. They could misread that or misunderstand it and say or think that the Engel findings mean that they have to find punitive damages, that the conduct, the conspiracy is enough, that the fraud is enough. And we didn't want that. We wanted the law to be accurate. We wanted the jury to be instructed that the binding effect that the court has told you about the Engel findings as to compensatory damages is not carried on to the punitive damages. In the initial brief and reply brief, Reynolds claims repeatedly that the instruction applied to both entitlement and the amount of punitive damages, and that's not true. It is only to the entitlement. So the question the jury is asked is, was the conduct egregious enough? And they're instructed, you may consider the Engel findings for this. They're not even required to consider the findings for this, but they may consider it.
Mr. Robbins,
yes.
How common or how frequently does it occur that a jury in an Engel progeny case is given the affirmative instruction that they may consider the Engel findings when they're determining entitlement to punitives?
There's nothing in the record that outlines all of them. I can tell you that in every one of my cases, which is 30 or 65 of them so far, the only one where it wasn't given was in Lido. Every other case, it is given that it is it may be considered, but is not binding. There are cases where the trial courts have given the opposite instruction, the instruction that Reynolds has asked for here, where it says that you may not consider the findings at all. But again, one of those was Lido, which resulted in exactly the problem that you'd expect. At the point that the jury is instructed that you have no basis to conclude that the product was defective, and you have no basis to conclude that there was a conspiracy, and you have no basis to conclude that there was a fraudulent concealment, that then the jury has no basis to find punitive damages at all. The jury can't say that that R.J. Reynolds sold a defective product knowing it was defective because, oops, they don't have any evidence that it's a defective product. They can't say that the fraudulent conduct was carried on with this willful and wantonness because they would have no basis to say or to know that there is a fraud. The jury cannot conclude that there's fraudulent concealment because that evidence is not presented. Now, while we do...
Counsel, isn't that exactly the point, that the evidence hasn't been presented to the jury for the purposes of their weighing the evidence to determine if it's appropriate to award punitive damages? How can they do that if they haven't seen the evidence?
The evidence they're presented with is the evidence of egregiousness, the evidence of willful and wanton conduct. They are not presented with the evidence that the product is defective, the fraudulent concealment and conspiracy, because those are Engel findings. They are carried forward. They are res judicata as to every case, every Engel case. No matter what happens, right through the end of the case, those findings exist. The only question is whether there is the egregious conduct to justify punitive damages. It's no different than compensatory damages. The compensatory damages are an element of damage, just like punitive damages, that are tacked onto or flow from the causes of action that are established by the Engel findings. So that is, Judge Long, it's not the point. The point is that the findings are the foundation for every Engel case, and they cannot be thrown away halfway through the case. And then at that point say, now plaintiff, you have to have proven that it was a product, that was a defective product. R.J. Reynolds did not ask for this other instruction that there's a lower burden. And that is really, it's beside the point, but I want to point out that they did not request that. They didn't request any instruction other than you may not consider the Engel findings at all. And that is an improper statement of law. It goes against Sofer, it goes against Douglas, it goes against the Engel res judicata findings. And so that is not really the right result there. The discovery violation in Nordine and the facts of Belle Glade that Mr. Burnett started with have nothing to do with this, because those both those cases said that the second jury has to come to its own conclusion about the egregious conduct that is a basis for sanctions or punitive damages. That's the same thing that's happening here. It's not that the jury is being instructed in this case that R.J. Reynolds acted with willfulness, a wantonness, and tried to intentionally injure people. If the prior findings said something along the lines of R.J. Reynolds acted with willfulness and wantonness, now that would be a finding that did not carry forward. In fact, the Supreme Court did not carry that forward, because remember, in Engel, the Supreme Court did not find res judicata as to the punitive damages. that something has to be independently proven. So those findings do not go along. And if we were going to, the Nordyne and Belle Glade are both cases where the judge had made findings in the earlier case, the prior decision, that the defendants acted with maliciousness. And I've lost my clock, so I don't know what's happening there.
You have a
Which
minute,
time?
45 seconds left.
45 seconds left. I believe that's about all, but Judge Lewis, I want to take just the last 30 seconds here and point out to you that, and that in the brief, in R.J. Reynolds' brief, it is based solely on a misuse of what you wrote in SOFR. And by truncating and taking parts and cherry picking words, R.J. Reynolds has tried to create a legal fiction, a canard, that the Engel findings have nothing to do with punitive damages, and that you, Judge Lewis, support that view. It is not true. And the Supreme Court decision in SOFR and Engel, and SOFR adopted what you had written in your dissent in SOFR. Those decisions support the idea and require that the Engel findings be considered by the jury just as the foundation for the causes of action, but they say nothing about egregiousness, and we have to independently prove egregiousness.
Thank you, counsel. Mr. Burnett, the floor is yours.
You're muted.
Mr. Burnett, we need
You're
you to-
muted, Mr. Burnett.
Thank you.
I'm so sorry. You missed some incredibly good points, but let me try to repeat them. Judge Nordby, I want to try to answer your question, if I may, about how frequently this instruction is given. We are going outside the record. What the record shows is in our proposed instructions, about 24 cases where the instruction we want to be given is given. Now, since then, since we proposed our instructions, both of the courts in Hillsborough County and Duval County have adopted all cases instructions, according to which all the trials in those two counties give the instruction or a version of the instruction that we have requested, that the juries are not to consider the Engel findings for purposes of punitive damages. In my experience, the instruction that was given here, the affirmative instruction to consider the Engel findings, is an outlier that differs from Mr. Rockenbach's characterization, and we're both going outside the record, so I don't know if you want to rely on that whatsoever. But the one record piece of evidence is our proposed instruction showing that the instruction has been given in at least 24 cases, around about that number. Mr. Rockenbach's presentation was focused on the language of SOFR. And he says that the jury has to be instructed with the causes of action. The most important words from the SOFR decision are these: the jury's determination of the factors for punitive entitlement by clear and convincing evidence do not vary depending on the underlying legal theory. Reynolds had argued that it was unfair to allow the jury to take advantage of the Engel findings for all the benefits they received and then recover punitive damages on two claims, defect and negligence, for which they could not have recovered punitive damages in the original Engel trial itself. The Florida Supreme Court said, it doesn't matter. It doesn't matter what the legal rubric is. What matters is the conduct, and whether that conduct satisfies these four factors that I have paraphrased for you. That's the most important part of the SOFR decision that refutes what plaintiffs have said here about the need to instruct the jury on the underlying bases of the causes of action. The plaintiff has mentioned the Lido decision. The third district's decision, there's no mention of the instruction in that case. It's not a jury instruction case. It's a directed verdict case. It's not applicable here. If you're going to read one thing, read the Belle Glade case. We cited it on page 25 of our initial brief. It also explains what this court said in Nordyne, so you're getting a 2-for-1. You can read Belle Glade and know what you did earlier in Nordyne. That case speaks directly to instructing the jury on the elements of the underlying cause of action when they interfere with the jury's determination of independent tasks to determine the basis for punitive damages. Mr. Rockenbach says that the issues in Belglade were not about the maliciousness or the egregiousness. That's not true. Just read it. I'm sorry, that they were about the maliciousness. The prior findings were about maliciousness. That's not true. The default judgment in Belglade was on the underlying tort claims, the elements of those claims. This further conduct evidence, these, I like to think of them as aggravators, mens rea aggravators required for punitive damages. Those weren't part of the underlying tort claims. And it's those issues that have to be decided independently by the jury for punitive damages. And so when you instruct the jury that these findings, which relate to these kind of mens rea aggravators, are binding on the jury, there's every reasonable possibility that they mislead and confuse the jury into thinking that they play a role for punitive damages. And under black letter preclusion law, under the SOFR decision, they do not. They are not admissible for those purposes.
And thank you, counsels, for your respective oral arguments this afternoon. This concludes our oral argument in this case.